Whereas in fact, the Constitution is not conferring rights at all. The Constitution is limiting the power of government. The rights are inherent. Human rights are inherent. And the 10 rights in the Bill of Rights are really intended to be for examples. And so Hamilton thought that this was a dangerous thing, and so did Madison initially. But Jefferson was gung-ho for this, you know, and they all had studied the history of England. The first Bill of Rights in 1638 came out of the lawsuit by the 4 knights over tax. Well, it's a whole long story. Anyway, so on February 12, 1788, he writes to Mr. Dumas. He was pushing hard. He's lobbying. This is Jefferson lobbying. He says, with respect to the new government, 9 or 10 states will probably have accepted by the end of this month the new Constitution. The others may oppose it. Virginia, I think, will be of this number. Now, this is Jefferson who had control over the Virginia delegation. He was the senior statesman from Virginia, and they were not going to vote yes or no unless he said to do so, even though he was on another continent. And so here he's issuing this threat. He's going to shut down the Constitution. Virginia, I think, will be of this number. Beside other objections of less moment, Virginia, will insist on annexing a Bill of Rights to the Constitution, i.e. a bill wherein the government shall declare that 1, religion shall be free, 2, printing presses free, 3, trials by jury preserved in all cases, 4, no monopolies in commerce, 5, no standing army. Upon receiving this Bill of Rights, she will probably depart from her objections, Virginia. And this bill is so much to the interest of the states that I presume they will offer it, and thus our Constitution be amended and our Union closed by the end of the present year. 5 months later, midsummer of 1788, he's writing, finally, Madison has kind of come around and become an advocate for the Bill of Rights. And Jefferson writes in another letter, he says, I sincerely rejoice at the acceptance of our new Constitution by 9 states. It is a good canvas on which some strokes only want retouching. What these are, I think, are sufficiently manifested by the general voice from north to south, which calls for a Bill of Rights. It seems pretty generally understood that this should go to juries, habeas corpus, standing armies, printing, religion, and monopolies. So you get it. Over and over and over again, Jefferson was very clear about what he wanted to be explicit in the Constitution, that these were areas where government cannot tread. That government, or areas actually where government is reserving in some ways its own powers in case of monopolies or not having a standing army. In other words, it's saying this is how these things shall be done. So, unfortunately, the Second Amendment, if you in the state of Pennsylvania actually had in its Constitution at that time in whatever the year was, 1787, I guess it must have been. Had in its Constitution an article that said that there would be no standing militia in the state unless during time of war. And it went on to say, in order to provide for a well-ordered militia, the right of an individual citizen to keep and bear arms shall not be infringed. And that entire language was lifted out of the Pennsylvania Constitution in the first draft of the Bill of Rights, and then it got watered down, and they did away with the no standing army provision, which is an interesting history of the Bill of Rights, but probably not germane to this. But back to corporations and monopolies. From the time, these guys, Jefferson and Madison, they were all very clear. The word corporation should not appear in the Constitution. They did not want that word in there because they did not want anybody to ever think that, well, they wanted the corporations to exist at the level of the state where they could be easily controlled. So from the founding of our country until the 1880s, for over 100 years, corporations' licenses to do business were revocable by the state legislatures if they exceeded or did not fulfill their chartered purpose. And they frequently were, by the way, corporate death sentence. The state legislatures could revoke a corporation's charter if it misbehaved. The Act of Incorporation did not relieve corporate management or stockholders and owners of responsibility or liability for corporate acts. As a matter of course, corporate officers, directors, or agents could not break the law and avoid punishment by claiming they were just doing their job when committing the crimes, but instead could be held criminally liable for violating the law. State, not federal courts, heard cases where corporations were accused of breaking the law. Directors of corporations were required to come from among the stockholders and be residents of the state. Corporations had to have their headquarters and meetings in the state where the principal business was located. Corporate charters were granted for a specific period of time. It varied from state to state. The longest I could find was New York State that allowed 40 years. The rest of them were typically 20 or 30 years. At the end of that time, the corporation had to be dissolved, its assets distributed, there would be a tax on those assets. The equivalent, this is the equivalent of probate, of just, a person dying there. And then if they wanted to reincorporate, they could do that to continue the corporation. But there would be an interruption period so that they couldn't amass wealth forever. They didn't want this to be an engine of infinite, in terms of time, and perhaps in terms of money, wealth accumulation. Corporations were prohibited from owning stock in other corporations in order to prevent them from extending their power inappropriately. Corporations' real estate holdings were limited to what was necessary to carry out the purposes of their charter. Corporations were prohibited from making any political contributions, direct or indirect. In fact, I'll read a law about that in just a second. Corporations were prohibited from making charitable or civic donations that were outside of their specific purpose of incorporation. State legislatures could set the rates that some monopoly corporations could charge for their products and services. For example, the railroads came later. And all corporate records and documents had to be open to the legislature and the state attorney general at all times. So, and in fact, this is a law that was actually on the books of the state of Wisconsin until 1954. Apparently, nobody noticed that it was there, and when they finally pulled it off, because it hadn't been enforced for at least since the 1880s. It's titled "Political Contributions by Corporations." No corporation doing business in this state shall pay or contribute or offer consent or agree to pay or contribute directly or indirectly any money, property, free service of its officers or employees or thing of value to any political party, organization, committee, or individual for any political purpose whatsoever, or for the purpose of influencing legislation of any kind, or to promote or defeat the candidacy of any person for nomination, appointment, or election to any political office. Yeah, they were pretty explicit. And then penalties. I mean, this to demonstrate that these guys are serious about this. Now, keep in mind, back in those days, $100 was several years' salary. It was a lot of money, and $1,000 was a massive amount of money. Any officer, employee, agent, attorney, or other representative of any corporation acting for and on behalf of such corporation shall violate this act, shall be convicted upon conviction, shall be punished upon conviction by a fine of not less than $100 nor more than $5,000. And by imprisonment in the state prison for a period of not less than 1 nor more than 5 years. Or by both. And then they go on to say, whereas, and if the corporation shall be subject to a penalty, then by forfeiture in double the amount of any fine, and if a domestic corporation, in other words, in that state, it shall be dissolved if after a proper proceeding and quoted for, et cetera, and if a foreign or non-resident corporation, its right to do business in the state may be declared forfeit. So, I mean, this is how clear these guys were about this. They were absolutely unambiguous. Historically, there were two categories of, quote, persons in common law. And this goes back to 7th century British common law, the origin of our laws. And back during the Heptarchy, the Saxon times of England, they recognized that there needed to be, in addition to a set of laws that regulated people, a set of laws that regulated institutions. They gave those institutions certain privileges, not rights, but privileges, so that they could be taxed, so that they could own land, so they could sue and be sued, so they could enter into contracts, things like that. And so these two categories historically have been called natural persons, which is you and me, and artificial persons. And everybody got it when the Republic was founded that, all of these things, the Constitution, for example, had to do with natural persons. There was just, no ambiguity about that. So, in 1773, after the Civil War was over, during Reconstruction, there was a faction within the Republican Party. They actually took over the party after Lincoln was assassinated and took over the legislature. They were the ones who impeached Andrew Johnson, called the Radical Republicans. And this was when the Republican Party, keep in mind the Republican Party that started in 1854 was an anti-slavery, what today we would call a very progressive party. And it was that way until the 1880s when they became captive of the railroad corporations. And since the 1880s, they've basically been the party of what Jefferson referred to as the wealthy and the well-born. But there was that little 30-year period where the Republican Party, and particularly the radical Republicans, were the real progressives. And Thaddeus Stevens was probably one of the most outspoken. And he helped write the 13th, 14th, and 15th Amendments. And the 14th Amendment, even its third clause, even provides that, I mean, he just wanted to punish the guys from the Confederacy, that anybody who had been in the Confederacy couldn't even serve in public office. I mean,